Friends and colleagues, in the first place, I'd like to associate myself with the remarks made by Minister Callery before lunch when he said what a huge achievement it is for Joe Mulholland to have made this conference such a central part of the Irish Constitution, I suppose you could say, using that word in its broadest sense. It's entertaining, it's elegant, it's a great place to be, and for purely personal reasons, I'm very grateful that I've been invited here as a late substitute for my colleague Dermot Keogh. I perhaps should mention that I come from a small Welsh village of population 1,100 people, which is 400 fewer than Glenties. And in that village, my maternal grandfather was a sea captain. In the 19th century, that was one of the only ways of making a career for a poor boy. My paternal grandfather was a bard or a poet, and so I have a great fellow feeling for Patrick MacGill, the naval poet. I had a colleague at UCC, rich in colleagues. To have such one colleague as Dermot Keogh is a great thing. And another one is the poet John Montague. And John Montague once remarked that it would be a great career move for a poet to be born in a place where you could have a congenial summer school. And I think he probably had Glenties in mind when he made that remark. Anyway, to come to the paper, which is called Bringing the Independence of the Judiciary Up to Date, and I'd like to start with a platitude, no bad place to start, and that is that the independence of the judiciary is enormously important, and never more so in a time like this, a time, as O'Casey, I think, said of chassis. In the past 2 years, the Irish body politic has had a nasty shock and needs to cling to a familiar and trusted institution which has served it well in the past. An average citizen might say, you could never trust the politicians and the media, and now you can't trust the church or the banks either, but at least you can rely on the judges. And I think that the reason why this hypothetical citizen would have spoken in these terms of esteem for the judiciary would be because they would be seen as a group of strong, fair people who do their work in the open, reach decisions according to principle, and then give reasons for those decisions. Now, there are two sets of duties which the judges of the superior courts perform. By the superior courts, I mean the High Court and the Supreme Court, and I'll be talking almost exclusively about those courts. The first of these two duties is to develop the Constitution, for undoubtedly a lot of the substance in the Constitution comes not from its literal words, but from the creativity of judges in interpreting it over the past 30 or so years. That's bound to be the case, isn't it? Because if you think about it, the Constitution in English is only about 10,000 words long. That's about 20 pages of a book, something like that. And it's covering the whole range of the governance of the state and the rights of the individual. So it's bound to leave a lot to the judges to flesh out in the context of cases which come before them from case to case and from one generation to another. So that there are a number of well-known examples in which the judges have significantly developed the Constitution. For example, in the sexual family area, they have updated laws to bring them into line with contemporary society. For example, decriminalizing the sale of contraceptives in the MacGill case, which was way ahead of the political process, ensuring that an adoption order may not be made without the consent of the natural mother, establishing an adopted person's right to know the identity of their mother. And I think one can add to that list decriminalizing male homosexual activity, which was a criminal offence in this jurisdiction until the early 1990s. I say I think one can add that because you probably recall the Norris case in which an argument that the statute criminalising gay male activity was unconstitutional failed by 3-2 in the Irish Supreme Court, but was reversed in the European Court of Human Rights. And I think for what I'm talking about today, you can regard all courts as coming together as a single judicial instrument. So I think you can bring that example in. Next, the Irish courts themselves have strengthened the civil liberties of the citizens. So, for instance, establishing a right to a passport, a right to privacy, including the right not to have one's phone bugged, a prisoner's right to communicate from prison with the media regarding an alleged breach of justice in his conviction, and also right to bodily integrity. That was laid down in a case involving fluoride in water, but it's sufficiently broad to embrace all kinds of state power, including compulsory inoculation, sterilization, torture, etc. My final example of important standards laid down by judges is the Crotty case of 1987, by which, before the government can ratify a treaty making a radical change to the European Union, then there must be a referendum. In other words, all citizens have the right to vote on that. One could say a lot about each of these examples. I'm not discussing their merits. The short point I want to make is that the Constitution is a short, general document which leaves a lot of the impact which it makes in particular circumstances to the judges, who are performing on behalf of the community a responsible act of creativity. And they're often working from phrases in the Constitution as brief and broad as, quote, personal rights. That's all the Constitution says in quite a significant area. Just those two words, like a rock climber facing an overhang with a very inadequate handhold, if you want to. Sorry, I made that cliche up myself. The second duty of judges is to protect citizens against the abuse of power by government or other powerful interests. Quite dramatic example concerned a 1990s case in which there was a long-established practice by which the Minister for Justice, Maura Geoghegan-Quinn, and some of her predecessors had been interfering with the proper administration of justice by the courts. The facts were quite extreme. In 1 year, 4,000 petitions had been made to the minister by way of deputies for the reduction of fines imposed in the district court, and half of those had been successful, and the judges stopped that practice. Traditionally, the law has identified the government as the big bad wolf from whom citizens have got to be protected. But we shouldn't forget that, especially in an era in which politicians accept they are unpopular and rather timid, there may be greater danger in some cases from popular business barons. A recent case in which a judge did his duty in speaking out to one of the most powerful of these, not just in Ireland, but I think we can say in the world, occurred when Michael O'Leary wrote to the Minister for Transport, Noel Dempsey, misrepresenting what had been said by Mr. Justice Kelly. Now, any lawyer would tell you what a grave thing this was to have done. It undoubtedly amounted to the crime of contempt of court. Very properly, Mr. Justice Kelly rebuked Mr. O'Leary, remarking, quote, "The truth and Ryanair are uncomfortable bedfellows," unquote. Mr. O'Leary went on to make an exemplary apology, probably in running for Apology of the Year, I would think. It was a fine apology. And here was a good example of a judge speaking truth to power, if you know that phrase. I haven't done as much research as I would like to have done on that phrase, but Wikipedia suggests that it's established in the 18th century for the Quakers, the Society of Friends, as their duty. But I think it's apt here. Another feature of judicial independence is the way in which it has been used where the state needs authoritative leadership by a person who is trusted as being above politics. I'm thinking here of the extrajudicial use of judges to chair tribunals and commissions. In the case of the 2009 referendum commission paving the way for the referendum on the Lisbon Treaty, the judge who chaired it, Mr. Justice Clark, by common consent, did a fine job in ensuring that citizens who wanted to be informed were given sufficient information in a difficult technical field so that they had sufficient information to make up their mind. Now, probably only a judge or a retired judge would have engendered public confidence in his neutrality in a complicated legal field bristling with controversial points. I can see there are difficulties in using a judge in this way. The British House of Lords judge, Lord Devlin, once remarked about the executive using judges in this way to plunder their independence. But I'm not going into that. I just wish to make the point that the use of judges in this way shows what respect there is for their independence and the usefulness of that to society. Now, my preliminary conclusion is that the independence of the judiciary is functioning well, and it would be a good thing if other institutions were in such good condition. I nevertheless think there may be room for moderate improvements, and I should now like to mention a couple of these. The first of which deals with judicial standards and conduct. We need a workable modern system for maintaining these and disciplining any breaches of them. Yet what we have so far is something which grew up in the 17th century. At the beginning of that 17th century, judges held office at, quote, the will and pleasure of the king, unquote. So if the king attempted to take away what we in 21st language would call the human rights of a citizen, then the judges, to their credit, leapt to the citizen's defense, and in many cases the king's reaction was to dismiss the judge. The next thing that happened is that Parliament, in alliance with the kings, won the mid-17th century civil war in England, and the Parliament then established that judges held office during good behaviour and could be removed, not by the king, but only by a resolution of both houses of Parliament. And this arrangement, unfortunately, was brought over unchanged into the modern Irish constitution. I say it was unfortunate because, of course, by now parliaments are subject to the party whip, and as President Ford of the United States put it, reflecting on a similar situation in the US, quote, you don't need evidence, you only need a majority. So the lame ducks, thus released in 1922 or 1937, came home to roost in the Sheedy case. Philip Sheedy, in 1999, had been sentenced to 4 years for causing death by dangerous driving. He was released early in circumstances which were thought to amount to improper conduct by 2 judges and a registrar. Now, the point I'm focusing on is how inappropriate the 17th century system was to deal with this episode. Mercifully and responsibly, the opposition parties did support the government, Nevertheless, hanging over everything was the fact that the Oireachtas was not the appropriate forum because of the danger of political interference with the judges, or the appearance of this. So, in the end, the three people involved resigned, and it didn't come to a messy vote, but it showed how close we had got to an inappropriate situation. By the early 2000s, in reaction to this sort of situation, a bill to set up a Judicial Standards Council had reached a fairly advanced stage of consultation with the judges. If you think about it, it's very appropriate, it's the only way of doing it, that such a thing should be discussed privately with the judges. But there was a delay, and in 2004, another somewhat similar episode occurred when Circuit Court Judge Curtin was accused of downloading child pornography. I should say that he has consistently denied this, but for the purposes of hypothetical discussion, we can consider what happened. And what happened was that, first of all, attempts to remove the judge were hampered by a Supreme Court action. After that was over, there was the fear that an election would be called before the dismissal proceedings had dragged their slow length through both houses of the Oireachtas. Then the machinery would have to be cranked up again. In short, this was another lesson in how inappropriate this politically compromised system was. Eventually, this April, all the judges sitting in council, not to be confused with the new body, which we haven't yet got, called the Judicial Standards Council, but all the judges issued a statement affirming support for forthcoming legislation to establish a modern system of standards and discipline for judges. The proposed bill is said to be based on the following system features. First, the most important of these is a gradation of sanctions to deal with offences of varying levels of seriousness. Thus, the sanctions would start at the lowest with a private reprimand by the Chief Justice, then they would move up through public reprimand to dismissal. Secondly, there would be lay representation on the Standards Council. Next, there would obviously have to be some limitation on what constitutes judicial misconduct. If, for instance, a judge is impatient or sarcastic with a party who is economical with the truth, or with a long-winded counsel, and I believe some exist, then that's not going to be a ground for discipline. Finally, there has to be fair procedure for the accused judge, including a sieve for weeding out insubstantial cases at an early stage. This last is especially important given that there are lots of disgruntled litigants out there who might try to rehash a case which they deserved to have lost, or perhaps deserved to have won, but anyway, the fact that they didn't had nothing to do with any impropriety on the judge's part. So you need a system for weeding out insubstantial cases. However, the announcement of this April regarding the establishment of a Judicial Standards Council went on to say that this would be conditional on the provision of recording facilities in all courts, all courtrooms. And I have two comments on that. First, given the economic climate, this could take many years. There is, in fact, a rather somewhat similar proposal for recording facilities to be introduced in all Garda stations in order to take the controversy out of the admission of confessions in criminal trials, a move which has, in fact, had that effect, but it took many, many years for it to be introduced because one had to wait, it had to be waited until these facilities could be introduced in every Garda station, and I think that the economic climate will probably have the effect that it will be many years before all courtrooms are equipped. I could be wrong. I hope I am. I believe it would be better in any case to introduce these, to introduce the system as and when a facility is introduced in a court in which it's relevant, rather than waiting for this day in the medium term in which all courts are thus equipped. I think that particularly because if you think back to the two well-known examples which I've spoken about just now, the Sheedy case, most of the action in it went on outside the court. You remember the dog walking in Ballsbridge, or Shrewsbury Road, perhaps I have the geography of it wrong. And in the Curtin case, the alleged action took place outside the court, so that the recording facilities would have nothing got to do with it. Here I pose to offer a reflection to old-fashioned persons, among whom I sometimes number myself. An old-fashioned person might well say, well, do you need a modern discipline and standard system? Why not just appoint people who can be trusted as judges and let them get on with it? I think the realistic response to such an objection is to say that we live in an age where in all fields, including churches, universities, God help us, there has been a change from this kind of self-discipline to accountability, and on balance, cases like Sheedy and Curtin show that there is a need for such a development. I don't know if anybody from the media is here. If they are, they will see that I'm leaving out my middle section because I'm running short of time, and I don't want to keep you from the main courses which are coming up. The final section I want to talk about is selecting judges, because prevention is better than cure, and the far more important matter than standards of disciplining judges is the system for selecting judges, because they occupy for 20 or so years what are undoubtedly the most influential unelected positions in the state. See the first part of my talk. The basic constitutional position is inadequate. The president appoints, but the government selects. And in an earlier era, those barristers who were well connected with the government party or parties and of adequate competence stood an excellent chance of preferment, whereas barristers of a different political persuasion, however suitable as barristers, didn't. However, despite this, the arrangements for selection never led to a judiciary which was less than independent. I think that's probably because of the strong culture of an independent bar, which meant that the judges' behavior was watched by an informed community with whom they respected very much their reputation. So there was nothing to worry about, but I still think reform is needed, for reasons I'll come back to. Reform has started to come from two directions. The first was that in the mid-1990s, successive attorneys general started to take seriously their duty to advise the government regarding the most suitable candidates for appointments, regardless of perceived party allegiance, and governments came to accept that they had to do as they were advised by their law officer. One of the most respected of these people we are mourning today, Rory Brady, and another we're fortunate to have in good health with us. Now, the second, more high-profile and probably less important change in this area followed from an unexpected controversy in 1994, arising out of the appointment of the former Attorney General as President of the High Court. His appointment was made over the protest of the Labour Party, which was a junior partner in Mr. Reynolds' coalition government in late 1994. The Labour ministers resigned, the coalition Mr. Reynolds' coalition government fell, and the incoming Rainbow Coalition established what is called the Judicial Appointments Advisory Board, having promised to do that because of the lather of indignation that was worked up over what had happened on the previous government. Now, this board acts only as a shortlisting agency in that its task is simply to recommend seven candidates who are deemed suitable for appointment, and the government then selects from this list. So the board weeds out really inadequate aspirants rather than selecting the best. There's no ranking, for instance. Now, the existing members of the appointment boards are the Chief Justice, the presidents of the other three courts, the Attorney General, a practicing barrister and solicitor, and three lay persons nominated by the Minister for Justice. That seems to me a sensible composition. I'm not criticizing it, but I am going on to suggest 5 other improvements which could be made. The first would be to make all solicitors eligible for appointment. This would significantly increase the number of possible candidates. The traditional argument proffered by the bar, which is, as you can imagine, very resourceful in working up arguments which suit its own interests. The traditional argument proffered by the bar is that most solicitors lack the necessary experience of court procedure to preside over a high court case. And consequently, what the legislation says is that the only solicitors who are now eligible are those with appropriate experience of Supreme Court or High Court practice. The fact of the matter is that the leading solicitors tend not to go to court very often. They leave that to the barristers. They remain in their office giving advice to very large companies and other important functions. Now, getting back to the point about the solicitor not being familiar with court procedure, that may or may not be necessary for High Court case, which involves hearing witnesses and acting as master of ceremonies. But I would suggest that there's no reason anyway why solicitors should not be appointed to the Supreme Court, and you then get a much larger reservoir of talent. Secondly, I think that wider soundings should be taken so that better information on each candidate is obtained. Thirdly, a major difficulty remains because a judge requires not just qualities of integrity, wisdom, humanity, open-mindedness, but also capacity to see the knock-on effects which striking down a law is going to have for the law and the structure of the state in the generations to come. And that's not the sort of thing which an advocate needs to know about. So I think that more attention should be paid to that. I think, therefore, that the Appointments Board, for instance, should hold interviews. And at this stage, I'd like briefly to mention that what I'm offering is not anything novel, because it has been done in most other states in the world over the past 10 years or so. We have ample experience in other comparable common law or cognate systems which enable us to see that these sorts of changes work. Very briefly, I'd like to mention the Scottish system. We've already had some references to the Scots. Scotland is the most useful foreign jurisdiction, partly because the population is comparable to Ireland. In the Scottish system, the candidates give a prepared presentation on non-specific topics. It's important that they should be non-specific topics, simply in order to not commit the judge for a case which may be coming up. And the sort of non-specific topics which they have given, so I'm told by a Scots judge, is, for instance, whether there should be a Judicial Standards Council, something I was talking about a moment ago, or what value should be placed on foreign precedents. The The fourth and the most important reform is simply that the government should trust the judicial board actually to make the appointment and not just to shortlist 7 candidates. This, in effect, is what happens in Scotland. The Scottish executive do insist on a system in which the appointments board provides them with a ranked list of recommended candidates, but indicated that they would reject a name ranked first by the appointments board only in very unusual circumstances. And if they did so, would give reasons for doing so, and in fact the Scottish executive has not yet exercised this power. So, winding up, if I had a wish to improve the Constitution, I should focus on the systems for appointing and disciplining judges. For technical reasons, the change regarding appointment could not be made without a constitutional amendment. The change in respect of the Judicial Council may or may not require a constitutional amendment. I think that certainly nobody would deny that to put the matter beyond doubt, you would need an amendment of the Constitution. And I think that apart from those technical arguments, there's another fundamental symbolic reason why we should have an amendment. It is to acknowledge the central position of judges in the Constitution, which they have helped to shape for the past 30 years or so, and to assure citizens that the judge's appointment and conduct is to be regulated by an open, efficient, and consistent system. At the moment, it depends very much on the integrity and on the opinion of one person. I think it's necessary in a republic, to go back to the main theme of this Congress, that citizens should understand that the independence of the judiciary is being underpinned in a way which doesn't depend on anything out of the 17th century, when the position of judges was quite different. And I might conclude by referring to Chief Justice Murray's remark in the Curtin case, when he pointed out that the independence of the judiciary is not a sort of a perk for judges, it's something which is necessary in a mature, modern republic. Thank you.